Hello and welcome to this online course entitled Law, Goods and International Trade, How Products Travel Across the World. In this online course, I'll be looking at some of the basic aspects of international trade law, international commercial law, and really getting to the core concept of how a startup company, a company who starts from humble beginnings, becomes a multinational enterprise, shipping products from one end of the globe to the other. So my name is Haris Mahmood. I am a Scots Law graduate from the University of Glasgow. I graduated with first class honours, and currently I'm working as a law tutor and shipping out these online courses to try and help students become more familiar with law and trying to help students and lawyers and general people from across the world become more familiar with legal concepts in the law. If you don't already know, I have two other online courses. One is Introduction to Scottish and Common Law, the other Introduction to International Law. Both I've done as areas of interest for myself, and they're both available on Udemy and Skillshare. So if you go on Udemy and Skillshare, if you type in Introduction to Scottish Law, Introduction to International Law, you can purchase that course. And if you email me, I'm willing to give you a coupon code as well to give you a discount. So who is this course aimed at? Well, it's aimed at a number of people. It's aimed at undergraduate students, any students who are studying subjects related to international law or international trade. A lot of the time, the law in this area can be very complicated. So breaking it down is very important. Master's students, LLM students who are about to study international law, who are studying an LLM in this area, in relations or trade, it'll be very, very important to get to grips with some of the fundamental concepts because, of course, in subjects like these, they get covered again in these courses in LLMs. So to get an introductory view is very, very interesting. And the general public, anyone who's interested in law, politics, countries, culture, economics, that would be me, just generally curious about every area. So the way I'm going to structure this course is we're going to look at a guy called Alex, and we're going to see how his product that he creates on one side of the globe, namely the USA, manages to travel all the way across the other side of the planet, and the legal instruments and the ways he's able to do that. So let's set the scene. Let's give a scenario. So Alex, there he is, stickman figure, lives in the USA, and he's been drinking green tea for several years. Okay. And what Alex says is that instead of drinking green tea only, he now wants to sell it. So he becomes an entrepreneur and he now wants to sell his own brand of green tea. Now, the problem for him is that in the USA, competition for herbal teas is extremely fierce, right? It's not very easy to penetrate the domestic market in the USA. There are tea brands that have been around for years, hundreds of years, and so it's not very easy for Alex to start selling his green tea straight away. But what he does is he notices that Thailand has a growing middle class, and it actually does in reality as well. And what the middle class love to do is to have extra money to spend on things that perhaps they don't need. And so there's an emerging market for herbal teas, right? People are richer, they're making more money, they have more free time, and so they'll drink things like green tea, right? So there becomes this market in Thailand. And what Alex is instead of focusing on the US domestic market, he decides to sell his product in Thailand, sell his product internationally. Now, in reality, I believe Alex would still go for the US market, right? So he would still try and penetrate the US market and then look abroad internationally. But for the sake of our presentation or the sake of our online course, we're going to take the assumption that Alex is only selling in Thailand, right? So he's gone straight to Thailand and selling internationally. So how on earth have products such as green tea managed to travel all the way from the USA, a country and culture totally distinct from Southeast Asia, and then they managed to travel all the way to Thailand? Now, today we take this feat for granted, right? The fact that products are able to move across different countries and continents. But that wasn't always the case. This is a relatively new concept in history. And I covered this in my international law course, where I say that a few hundred years ago, these countries, they wouldn't even have known about each other. They might as well have been on different planets. And so because of globalization, now we are very, very well integrated as a global community. And so we're able to trade with one another. So to summarize, what Alex will have to do in order to get his product from the USA to Thailand is he will have to weave his way through a complicated web of legal, logistical, and political hurdles. And those are the things that I'm going to cover in this course. But if it works, the benefits seem to be clear, right? Thai citizens, they get a new product, they get herbal teas or a green tea and a nice new flavoursome green tea. The Thai government gets happy citizens, so it's beneficial for them to let Alex come into Thailand and sell his products. And of course, Alex benefits because he gets rich, right? So it's a win-win-win. At least that is the ideal scenario for international trade and this globalized economy that we have. Of course, it doesn't always work out like this. You know, people can exploit international trade for their own benefits. But as we will see, overall, at least is my opinion, the idea of a globalized economy has lifted millions out of poverty. It's expanded products across the world. And we look at why this is so important. And so the aim of this course overall is to look at how different areas of law help to facilitate and regulate international trade. And we'll be doing this through a number of topics. And what we want to do is we want to answer some fundamental questions about how Alex exactly can get his products into Thailand. So this lecture would be the background and setting. But the next one will be look at, well, how does Alex create an international sale of goods contract? Okay, these are some of the legal hurdles that he'll have to overcome. How does Alex ship his products internationally? How does Alex find more foreign buyers for his product? Well, how does he expand his business internationally once he's got a solid base? And how will Alex deal with restrictions from the Thai government on his products, right? So these are the questions that we're going to answer through a series of 6 lectures. And the way we're going to answer them, the method, is by looking at, first of all, sale of goods contract law, international sale of goods contracts. Then we're going to look at international rules on shipping. Then looking at rules on sales agents and distributors, foreign direct investment, and World Trade Organization, and this idea of protectionism. So it's a really, really fundamental question. And really, this is the basis of these lectures and trade and globalization in general. And that is, why is international trade important? Why have you decided to purchase this course? And why is it worth you learning about international trade? Well, I've come up with a series of reasons, a number of reasons I think that it's really important. There's an idea that it can reduce poverty, that there's less poverty with more international trade, because trade and investment means more money in a country. And that money is used for taxes, and taxes are used for public services and creation of jobs. There's the idea that there is less war with more trade. So when countries are dependent on each other, they're then less likely to go to war with each other. So if I'm going to trade, if I'm Germany and I'm about to trade with France, I'm not about to invade France because I rely on them to fund the war anyway. So there's no way I'm about to invade them. More human cooperation, right? Trade can be used to connect different cultures and communities as people travel more frequently for different reasons, okay? Kind of opens up borders to different cultures. And better services and products. When you have more competition in a domestic industry from different people across the world, so companies know they're not safe and they can't just churn out the same product because someone else will have a better product. So it means they keep innovating, okay? And we as the consumers get better products, we get better services for cheaper rates. And that contributes to growth and prosperity and you name it. Welcome back to this online course. We're looking at law, goods, and international trade. How Alex's green tea travels across the world. Okay. In this lecture, we're going to be looking at international sale of goods contracts. Now, a quick disclaimer, the law that we're going to look at, which is the CISG, is much, much more complex than I will cover in this lecture. And the reason for that is because it's a huge international convention which regulates international sale of goods contracts from people from across different jurisdictions. So it deals with a number of different issues. And I have pretty much summarized maybe around 3 or 4% of it in this lecture. So it's really, really basic. And if you do want some more detailed information, I'd highly recommend looking at more specialized source for international sale of goods law or contract law in general. But anyway, let's answer the question. So how does Alex create an international sale of goods contract? Of course, he needs to sell his green tea, doesn't he? So he needs a contract with someone in Thailand to sell it. So let's set the scenario. So it's very, very inefficient for Alex to sell directly to consumers in Thailand. He doesn't know the country well, he's not established, he doesn't have a clue about the local language, the population doesn't know anything. It's much more efficient for him to actually sell to a retailer in Thailand, and who can purchase his products in bulk and then sell them to customers, because they're much more acclimatized to the local conditions, they know the language, they know the people. And so in order to do this, he'll have to create an international sale of goods contract. So this is assuming that he's found someone in Thailand, maybe a shop, a retailer, that he's willing to do business with. And in order to give the products to him, he'll have to create a contract. And that's regulated by this thing called the UN Convention on the International Sale of Goods, shortened CISG. Let's look at the product supply chain. So Alex will be acting as a manufacturer slash supplier. Normally, he might have another manufacturer, right, giving him the green tea, but we're assuming here that Alex is making the green tea as well as supplying it. Okay. So Alex would be acting as a manufacturer slash supplier. He'll then be shipping off the products to a retailer in Thailand, which could be any shop in Thailand, a tea shop in Thailand. And that tea shop will sell their products to consumers, okay? And they'll sell them to the consumers in Thailand. Now, the CISG will cover the manufacturer to retailer contract. It won't cover the retailer to consumer contract, because it has to be a business to a business contract under the CISG. A quick background about the CISG, the UN Convention on Contracts for the International Sale of Goods. It was created in 1988, and the whole purpose of this was it was used to homogenize contracts in international trade. Because when you have a globalized economy and you have businesses in different countries all trading with each other, you have to have set contract terms, because it makes the process much, much easier. And it makes the process easier in the sense that if there's a dispute between two businesses in two different countries, you then know which law to apply. Otherwise, you'd always be bickering about whether you apply one country's law over another's. And so the CISG was used to homogenize this. And it's been signed and ratified by 94 countries. Now, of course, there's 196 countries, I believe, in the UN. So around half have signed the CISG, which means that half have not. And so what happens when you have a business in a contracting state signing a contract with a business in a non-contracting state? Well, that's where problems come in. And so this is a work in progress to get more and more states signed up to the CISG. So if we look at content and what the CISG actually entails in terms of contract law, we're going to be looking at some of the basics of contract law in general. So scope, CISG only applies to contracts if the following requirements are met. And that would be the contract has to be a sale of goods contract. So if it's a sale of services, it doesn't apply. The subject matter can only concern formation of contracts. Okay, so that's a very specific area which we'll look at. Rights and duties of the buyer and remedies of the buyer and seller. It won't look at a lot of other areas of contract law which are regulated by domestic law. Okay, so this is really the bare bones of contract law it regulates. Parties to the contract have to have their place of business in different states. Okay, otherwise, if they were in the same state, that would just be regulated by domestic contract law. So this is international contract law. It has to be different states. And at least one of those states has to be a contracting state, as in a contracting state to the CISG. Okay, so one of those countries has to have signed up to the CISG. Otherwise, the CISG doesn't apply. Finally, the CISG will apply automatically as long as the parties haven't explicitly opted out of the CISG in the contract. So unless you've stated in the contract that the CISG does not apply, it will apply automatically, as long as the other conditions are met. Interpretation of the CISG. So judges and lawyers, they have to interpret the CISG based on these following characteristics. So international character, the courts have to interpret the convention in line with international rather than domestic principles. Promotion of uniformity, so the courts have to interpret the CISG similar to how other courts have interpreted it instead of using their own methods. The idea that the CISG, or any rules that the courts make, they're uniform, they all make sense, they don't contradict one another. And they have to observe good faith. They have to go by the assumption that the parties have trust between each other and there's good faith between each other. So here we get into the rules, the specific rules about contracts themselves, okay? So if we look at one of the most fundamental rules, it's formation of contract. A contract is formed where there is an effective offer and an effective acceptance. So an offer is a proposal for concluding a contract addressed to one or more specific persons, and it becomes effective when it reaches the offeree. You could write entire dissertations just about effectiveness of offer and when it's actually effective and who it has to be addressed to specifically. So I'm literally summarizing loads and loads of law in 2 lines. Okay, so just bear that in mind when you're learning this section of the course. And the other part is acceptance, right? So you need an offer and acceptance for a contract to be formed. And so a statement or other conduct of the offeree which indicates assent would be an acceptance. And that becomes effective when it reaches the offerer. So the other aspect that the CSG deals with is the seller's obligations and the buyer's remedies, okay? So where the seller fails to fulfill his contractual obligations, the buyer will have a number of remedies available. So what are these seller's obligations? Well, pretty straightforward, right? He needs to deliver the goods to the buyer, and he needs to ensure that there's conformity of the goods that the buyer asked for. The right size, the right shape, the right color, take your pick. But what happens if he fails to fulfill these obligations? So what happens if the goods are totally wrong or they're broken? Well, the buyer has a few remedies available. He can ask for specific performance. So that is where he goes to a court and he tells them to compel the seller to remedy the defect, okay, or to compel performance of his obligations. So if the seller doesn't deliver the goods, the buyer can go to a court and the court can tell the seller, you have to deliver the goods, basically being told off by the court. Avoidance of contract is basically making the contract void altogether, so cancelling it completely. Damages, where the seller would pay money for the buyer for any damage that he's received. And self-help, so the buyer can do things himself to remedy the seller's failed obligations. So for example, if the seller has delivered the goods late, then the buyer can not pay him the full price, right? You can just pay him like half. Okay, so that'll be a self-help remedy. Conversely, we're also looking at the buyer's obligations and the seller's remedies. So what happens if the buyer is the one this time that fails to fulfill his contractual obligations? Well, then the seller has a number of remedies available to him under the CISG, right? So the buyer's obligations, again, very straightforward, is to pay the price, you have to pay, and to take delivery of the goods. And what are the seller's remedies if he fails to perform them? Well, there's a thing called an action for price. It's very similar to specific performance. It's basically where the court will tell the buyer that he has to pay. Avoidance of contract, make the contract void altogether, and damages. And finally, we're going to look at one more aspect of the CISG, okay, and it's called risk, this thing called risk. When does risk transfer? So what is transfer of risk? It's basically the moment at which the seller's obligations, the ones we looked at, okay, so for example, to deliver the goods, actually become the buyer's obligations to pay. So at what point does the seller, when he delivers the goods, does the buyer then have to receive the goods or pay the price? At what point, and this becomes a fundamental issue in court cases and disputes, okay, at one point did the seller fulfill his obligation, and at what point did the buyer fail to fulfill his obligation? And under the CISG, for contracts of carriage, that's when there's delivery of goods. Risk will be transferred from the seller to the buyer as soon as the goods are handed over to the first carrier. Essentially, it would be a scenario like this. So say, for example, that is the seller. As soon as she hands over the goods to the carrier, who is going to then ship them over to the buyer, that's when risk is transferred. That's when the buyer is under the obligation to pay and take delivery. Before this moment, it would be the seller's obligation to make delivery and make sure the goods are conforming. And then the goods are put onto a cargo ship and then they arrive at the buyer's house. So that would be the basis of risk transfer. It's a little bit complicated, so you might have to watch this bit again, but it becomes a very, very fundamental issue, especially when there's a dispute. Hello, welcome back. We're on lecture 3 already of this Law, Goods and International Trade online course. So in this lecture, we're going to be looking at shipping. Now, it seems like a little bit of a boring or tedious topic to look at, but actually it's one of my favorite topics. It's actually really interesting because it's all about logistics, right? It's okay saying that this law helps you to take the products here. Shipping is something practical, right? This is a practical hurdle, probably the biggest practical hurdle of literally how to get product from the USA all the way to Asia, right? All the way to Thailand. So it's actually a fundamental aspect of trade. And you know, without it, and without these really, really complex shipping systems, you wouldn't have all the products in your house. So we're answering the question, how does Alex ship his products internationally? Okay, and we're looking at rules on shipping. So once Alex has actually found a reliable buyer and he's concluded his contract terms, remember under the CISG from the last lecture, Alex now needs to find a way to actually ship his green tea to the other side of the planet. Now, it seems like a really, really tough task, right? But luckily, humans have refined and improved this area of logistics throughout centuries. And they've made transport really, really convenient, really easy. And so products have managed to travel from continent to continent with pretty much seamless ease. And how Alex is going to ship his products according to a law point of view is he'll rely on a set of international commercial terms called Incoterms, and that will help the shipping process to run smoothly from a legal point of view. So today, shipping seems like a really straightforward process, right? So you basically take goods, you load them onto the ship, they go from point A to point B, and Bob's your uncle. But historically, this was a really long, risky, and inefficient process for a long, long time. And it's really only very recently in human history that we've managed to expedite the process, made it safer, made it easier, and that's how we're able to have several thousand products just in one room. So there's some key developments in shipping and trade that have made this process much more easy, much more smooth. And I've gathered a list of some of these developments in order to show how shipping went from this really, really risky, really unsafe journey to becoming seamless and smooth like it is today in the 21st century. So the use of small and light products was very, very interesting. Previously, whatever the product was, it was just sort of stuffed in to a cargo ship or a sail ship back then, and it was just transported all the way over. But that wasn't very efficient, right? It wasn't a very productive use of space specifically. And so the use of small and light products sort of as a vector means that we can utilize space much more efficiently. So I'll give you an example, right? So let's take water. If you were to just pour water into a shipping container, that's actually really, really heavy. Okay, it's heavy and actually you won't get as much volume in it. So what happens with water is it's embedded into crops. It's called water embedding because crops take up much, much less space. So instead of you pouring water into a container, you embed the water, put it into a crops, put the crops in the shipping container, and then that gets transported and you get more water for less space. Okay, so it's a really, really ingenious way of shipping products. The second development that was really interesting was the advancement of ships in general, right? So these sea vessels went from being powered by sail to being powered by steam, and now today they're powered by petrol and diesel engines. And so this is the evolution from sail ships to steam ships to now the cargo ships that we see today. And that's just made these ships bigger, but it's also made them easier to control and less dependent on the weather. If you were a sail ship, as we can see in the picture, right, that's a sail ship, you're always hoping that the weather is in your favor. And remember, we cannot control the weather. So you're basically hoping that forces beyond your control will be in favor for you just to get some products across the other side of the planet. So that's a really, really risky, really, really dangerous expedition. And now with cargo ships, there's more stability, there's more security, there's more certainty. Canals have also made shipping, the whole process, much, much quicker. And we're going to look at two of these canals, but essentially these canals are totally man-made. It's land that's been hacked off and with water filled in it so that a ship can cross, and it will link two oceans that previously, if we just went by, physical borders, we wouldn't have had. And so by linking these two oceans, we've managed to absolutely slash journey times for ships. And so that's why products are able to get into our house within a week of ordering them, even though they're coming all the way from like China. And finally, the use of shipping containers has also made shipping much, much easier. So before shipping containers, it's crazy to imagine that there was a world before shipping containers. So before then, there was just these individual barrels, right? So the products would just get stuffed into whatever barrel was available and then just get put on the ship. With shipping containers, you can pack a cargo ship much tighter, and you can load it and unload it much quicker because there are cranes now on cargo ships. So they are specially designed for these shipping containers. So everything is sort of homogenized, okay? Everything's the same. These shipping containers are very similar to each other. They've got hooks and they get unloaded and loaded very quickly. With an individual barrel, if you imagine a barrel, it requires manpower to get them off and get them on, and you can only do one at a time, really. You can't have two barrels at one time with one person. So it's made the whole process much more mechanized. So we said we'd look at the canals that have made shipping and journey times of ships so much quicker. So here's one of them. It's the Suez Canal. It was built in 1869. And there it is on a map, okay? So it's now in the territory of Egypt. And if you can see the two seas over here, right? You see the Red Sea and the Mediterranean Sea. Without this man-made canal, these two oceans or these two seas are not linked to one another. And so then what you would have to do if you wanted to get from the Red Sea to the Mediterranean is you would pretty much have to go all the way around Africa. okay, if you wanted to get to the Mediterranean Sea, or if you wanted to essentially get to Europe. So this canal just makes shipping so much easier. Now, instead of going all the way around the Horn of Africa, ships can go pass straight through the canal and get straight to Europe. And so that becomes a problem like it did recently when the canal became blocked by a cargo ship. So weather conditions were really bad and the canal is quite narrow, okay? So if a cargo ship is coming, the cargo ship essentially turned 180, okay? And it was blocking the entire canal. And there was a crazy statistic, like billions of dollars of worth of goods were being stopped from passing through the canal every day. It was like a week and a half or 2 weeks before they managed to unstuck the cargo ship, get the canal open again. So it's a vital, vital channel for international trade. The second canal is the Panama Canal. It was built in 1914. Okay, and here it is. It's in Panama, of course. And here's the canal situated here. And what that does is it cuts journey times, because in order to get from the Atlantic to the Pacific Ocean, you'd have to go all the way around South America. And this is totally blocked off. And now ships are able to go straight through the canal and get to the Pacific Ocean that way. Again, cutting journey times, making trade so much better. So what is the law that actually regulates shipping? Well, the closest thing we have is these things called Incoterms. They're international commercial terms. And what they do is these are terms you can add into a sales contract, which will regulate the rules of shipping. So how a product is to be shipped and specific rules surrounding that. So they were first published, these Incoterms, by the International Chamber of Commerce in 1936. And the International Chamber of Commerce is an international organization made up of businesses. And what they do is they have thousands and thousands of businesses signed up to them, and they all try and cooperate because they all have an interest in international trade being more smooth and more efficient. And the Incoterms were used to settle these uncertainties about rights and obligations in relation to transporting goods between the buyer and the seller. And although the Incoterms are not official law, right? So officially they're not law in the sense that no one can rely on them in court. Courts still do see them as quite good practice, okay? They see them, if you've got Incoterms in your contract, they'll see that that contract is quite a good contract. It's been well thought out, okay? So they're very seen very favorably, but you can't rely on them as law in itself like you can rely on the CSG. So there's different types of Incoterms. The type that you use in your contract will largely depend on the type of relationship you have with your seller or the relationship you have with the buyer. And I'm going to go through some of them. And I think there are 14 different sets of Incoterms, and I'm only going to look at four main ones. First one I'm going to look at is Ex Works, abbreviated as EXW, right? And you would use Ex Works where you want risk. Remember, we talked about risk in the last lecture. When you want risk to pass from the seller to the buyer at the seller's own place of collection. And in this Incoterm, the buyer will pay all transport costs. So if we try and map this out, and we have our green T here, and our green T here, and this is the product, this is going to represent when risk passes from the seller to the buyer. And so as soon as the products are laid by the seller for collection, so for example, if the seller has a warehouse and he's making his products, as soon as that green T is ready, according to EXW, risk has passed to the buyer. So it's now the buyer's obligation to find a way to get the products to him. And it's the buyer who'll pay the costs for all transport to get those products all the way to him. Seems like a bad deal for the buyer, right? He not only has to go all the way to get the products from the seller, but he also has to pay for it. Well, some buyers just offer this kind of as an incentive. So they will be very experienced buyers. The seller might be very inexperienced. And so just to make it easier for them, the buyer will have this contract term. And then maybe eventually, as the seller becomes more experienced, they'll change it to one of the Incoterms that we'll look at later on. Free on boards is another type of Incoterm, FOB. And this is where risk passes when the seller loads the goods on board the vessel, which would be a cargo ship, for transport to the buyer. And in terms of costs, the seller would pay the transport costs until the goods are on board the vessel. So that would be inland transport. And then the buyer pays transport costs after they have boarded the vessel. So let's look at an example again. This is when risk will pass. It's when the goods are on board the cargo ship. So that's when the buyer has to fulfill his obligations. Seller pays some of the transport costs. He'll pay the costs until the goods get to that cargo ship. And the buyer will pay the costs after that point. Okay, after the goods are loaded onto the cargo ship, the buyer will pay those. The next one is CIF, cost, insurance, and freight. So the risk is the same as FOB. It will pass when the seller loads the goods on board the vessel for transport to the buyer. But in this scenario, the seller will pay transport costs all the way until the buyer's port. Okay, so he'll pay pretty much all of the transport costs. So again, let's look at the example. Risk is the same as before, right? Until the goods are on board the vessel. But this time the seller pays everything. Okay, inland transport beyond blah, blah, blah. And finally, we have DDP, right? Delivery duty paid as an Incoterm. And this is when risk will pass when the goods actually arrive at the buyer's port of shipment. Okay, so not when they're loaded onto the vessel, but when they actually arrive at the port of shipment of the buyer. And it's the seller who will pay all of the costs just like before. So we have this scenario. That's when risk will pass. It's when the goods are actually at the buyer's port of shipment, which means the seller has to fulfill his obligations all the way until they're at the buyer's port of shipment, right? And then on top of that, he also has to pay. So you think he's getting quite a bad deal here, right? Why would any seller want to go for DDP? Well, actually, it's a business decision. Sellers might offer DDP Incoterms to entice buyers to come and contract with them instead of going to another seller who might have a more favorable contract term, such as FOB. And so they can reduce their competition. Perhaps they can even charge more for their product, right? Because they're offering such favorable shipping terms. And so often it's used as a business decision. And so the type of Incoterm you use will depend on your circumstances, but it's vital that they're included in a contract just to make the process much, much easier. Hello, welcome back. We're on lecture number 4 of Law, Goods and International Trade. And in this lecture, we're going to be talking about sales agents and distributors, aka people who might act as middlemen as Alex tries to expand his business. So how does he find more foreign buyers for his product? So sales agents and distributors, let's set the scenario. Where are we in Alex's life journey in selling his green tea? So Alex has been steadily selling his products to the same Thai retailer for a while. Remember that retailer that he made a contract with during the international sale of goods? But he really feels that he should be expanding. He's doing well, he's selling a lot of products, but he should be going to a lot more retailers in different cities. He could be making 10 times, 20 times the amount of money that he's making now if he starts to sell to more shops and all these shops start to compete with each other. So it's inefficient for Alex to personally search for these Thai retailers. So what he's going to do is he's going to make use of sales agents and distributors, and they're going to act as middlemen, and they're going to help Alex find people in Thailand to sell to. Otherwise, Alex would have to go all the way over to Thailand and find them himself. But of course, he doesn't speak the language, he doesn't know the culture. It's a bit difficult. So what Alex is going to do, use these, sell more green tea. So sales agents and distributors, what actually are they, right? So if you look at sales agents, an agent is a person who has the authority given to him by another person, aka the principal, to act on his behalf. And a common example of an agent would be just an employee of a company. As an employee of a company, I am the agent of my boss, and my boss is acting as the principal. So I'm under his authority and I act on his behalf as an employee. And so in this case, the agent would be the person finding the shop in Thailand, and the principal would be Alex. And then secondly, we have distributors, right? It's a little bit different. So a distributor is the person who buys goods from another person, the supplier, and with a view to reselling the goods to other buyers. So instead of me being a direct employee of my boss in this case, if my boss wanted me to sell goods, or he wouldn't be my boss then, if someone wanted me to sell goods, I would just buy it from him at a discounted rate probably, and then go and sell them to other people. So I'll take possession of the goods. I'm no longer under his authority, right? I can pretty much do what I want. I can sell them how I want. And in the product supply chain for a sales agent, remember last time we looked at manufacturer, supplier as Alex, we've got a retailer, and we've got the consumer as well. There's an extra dimension now. With a sales agent, you have the principal, which is Alex, who gives products to the agent, who could be Alex's employee, who will then find retailers, shops in Thailand, who will then sell it to consumers, the Thai tea drinkers. And then for distributors, it's very similar, except this time Alex is acting as the supplier, gives it to the distributors in Thailand, shops in Thailand, they give it to the shops in Thailand, and they give it to the consumers, okay? Now, with this product supply chain, there's not just 4 players in the product supply chain in international transactions. Sometimes there's loads of others, wholesaler, manufacturer, etc. There's a lot of people coming together to try and get these products from one place to another. but in a simplified version. So what's the applicable law, right? So when it comes to rules surrounding sales agents and distributors, what law is applicable? We know with contracts, international sale of goods contracts, is a CISG, there's a treaty for that. We know with shipping rules, it's the Incoterms. But with sales agents and distributors, what is the kind of international law that applies? Well, there isn't one. There's no international treaty or convention on rights of sales agents or distributors, right? It's regulated largely by domestic law. And in this case, the domestic law would probably be Thai domestic law. But having said that, there have been some attempts to internationalize the law in both these areas. So in sales agents, in EU law, which is kind of a form of international law, there's Council Directive 1986, and that has some rules on the protection of commercial agents. And the UNIDROIT, which is this organization to try and uniformalize contract law, right, international contract law principles. There was a convention, well, there was an attempt at making a convention called the Convention Agency for the International Sale of Goods, and that pretty much would have regulated international sales agents laws. The problem was only 5 states contracted to it, and so it's not in force. And considering it was created in 1983, I mean, you pretty much imagine it's pretty much dead now. So that wasn't a great success. With distributors, it's even less international law. The only attempt really there has been is in the CISG, right, that we spoke about before. And there's an idea that the CISG may regulate some aspects of supplier distributor contracts instead of only regulating supplier retailer contracts, right? But the law is very unsettled. There's a lot of different opinions. So again, it's not very clear. So largely it's regulated by domestic legal principles, whatever the law is in Thailand. In terms of obligations of the parties, what each party needs to do now, that would obviously be in law, but there are some general obligations. So with sales agents and distributors, they're not going to be that different in any different country, right? So, you know, they're going to be pretty similar, whether it's in Thailand or the UK or whatever. There will be some differences, but they will be generally similar. So when I talk of obligations of sales agents and principals, right, or obligations of suppliers and distributors, I'm talking very, very generally and not with reference to any specific legal act or convention. Overall, here's the obligations for sales agents. So these are some of the things that sales agents need to make sure that they do. So they must look out for the principal's interests. They must act in good faith. They have to promote the sale of the goods as well as market them as well. They have to exercise reasonable skill and care, and some legal jurisdictions have diligence on there as well. And they have to avoid conflicts of interest. There's a number of other obligations as well, but these are kind of a general list of things that the sales agents has to do in law. And on top of this, the principal also has his own obligations, right? So he has to remunerate the agent. So whatever the agent does, if he acts for him, and if he's finding retailers in Thailand, then he's an employee and he needs to get paid, okay? And a lot of the time, they'll get paid with bonuses as well. So if they find a lot of clients, they'll get bonuses. So the principal is under an obligation to remunerate the agent, must not interfere with or reject any agent dealing. So if the agent is in the middle of a contract and he's trying to find retailers and he's in the middle of it, if the principal comes and keeps butting in, the agent's never going to make any sales. So he has an obligation to just let the agent do what he wants, okay? Give him authority. And he also has to protect the agent from claims and liabilities, because if an agent is acting under the authority of the principal, then if the agent runs into any liabilities, legal liabilities, if there's any legal action against him, then it's not the agent that will be liable, it's the principal, because the agent is only acting on behalf of the principal. Really, it's the principal that's acting through the agent. So he then needs to protect the agent personally from any claims and liabilities. Now that will go in as far as the agent is actually doing his duties. For example, if the agent is meant to be looking for retailers, yet instead he kills someone, well then that's not going to be liability on the principal, right? Because the agent wasn't doing his duties, right? That was never in the contract. So it needs to be reasonable. In the same way, you also have obligations for distributors and suppliers. So for distributors, they must not obtain goods from other suppliers. They must not market or resell goods outside of the territory in the contract. So if that distributor begins reselling goods in Vietnam instead of Thailand, that would be against the contract, right? That would be illegal normally. He has to promote and market the goods, And he has to make it clear that he is acting as a distributor, not just as an agent, or not as the principal himself, right? Or sorry, as the supplier himself. He has to make it very clear to people that he's kind of like a third party, a middleman. In terms of the supplier's obligation, you must not appoint other distributors to compete with the original distributor, because then there's no point of that if you're starting to give your products to all the distributors and they begin competing with each other. The whole point of being a distributor is that you have a kind of exclusivity with the supplier. You must not supply goods to an agent to sell. So, I mean, it depends on which jurisdiction, but normally a company won't have both an agent and a distributor. You must make sure the goods comply with statutory regulations and licenses, and he has to provide the distributor with enough information to actually sell the goods. You need to give all the information, what's necessary, in order for the distributor to have the best chance of selling the goods. So which one should Alex choose? Should he choose sales agents to market the products in Thailand, or should he choose distributors? Well, it entirely depends on your business model, the country that you're about to sell in, the country's market, and the way they do business. So it's very, very case specific. But here are some of perhaps the advantages and disadvantages of each. So with sales agents, some of the advantages is that, well, if he's an agent, you have more control and direction over how he's going to sell the products. There's also no ceiling to how many products that can be sold. So the agent could, theoretically at least, find loads and loads of Thai retailers and you could just keep selling products all year round, right? But the downsides is that sometimes with an agent, since he is an employee, it can be hard to fire in some countries, even when the agent isn't doing his job very well. So especially in some socialist countries, it can be hard. Workers' rights are very strong, so it'll be hard to fire a sales agent. And so that means you just get a really, really crap employee that, you know, is taking your products and not selling anything, and that would be a waste of money for you. And with an agent, there's a risk that the products won't actually sell, because of course that it depends on how skilled he is. And what if they don't sell? That means that regardless, you'll have to pay him, because if he's tried, you need to pay the agent for their time. Yeah, you might not give him the bonuses and stuff, but you'll have to pay some sort of base salary. And so there's a possibility that you could be losing money every year with sales agents. And of course, legal liability falls on the principal. So whatever the agent does, you will have to be legally liable for it, which means that if the agent sometimes screws someone over or rips them off, you might be liable. And so that'll cost you even more money. There's a financial risk with this that comes with it. Some of the advantages is that a distributor contract is often easier to cancel, right? Because it's just a contract. And so it's regulated by private law. And so the government rarely gets involved with private contracts until it's easier to cancel. Having said that, there are some cases where the government has got involved, because there are some suppliers who, what they do is they find distributors in a country. Distributors then find these contacts. The suppliers get a hold of the list of names that the distributors distribute to, and then cut out the distributors completely and then start selling directly to the retailers. So there are some governments who now regulate that completely, and make it very hard to cancel the contract, which makes sense, right? It's quite unethical to sort of make someone do your dirty work at the start and then take the rewards at the end. With distributors, there's also less risk whether the products will sell or not, because remember, you're selling them in bulk to them. When you sell products in bulk to distributors, it's the distributor that takes risk of whether, if they manage to sell them on to the retailers. So, I mean, and you're laughing all the way to the bank because you've sold these products, and regardless of what happens, you're going to get money. And of course, legal liability falls on the distributor, so you're not liable. But the opposite side is that you have less control and direction, right? So you're relying on the distributor's reputation. So if he markets your product poorly, or if he markets it in a bad way or in an unethical way, that is not only a risk to the distributor, of course, but it's also on you, because he's selling your brand. So it reflects badly on your brand. So you need to pick your distributors well. You need to pick your distributors carefully, make sure they're ethical, and make sure that they are reputable as well. They have a good reputation. And with distributors, payment's taken as a lump sum instead of a continuous sort of payment that comes with sales agents. Sales agents could find retailers all the time, and keep giving you this regular source of income. Whereas with distributors, you'll sell the products and you'll just get a lump sum. And for some people, getting a big lump sum just maybe isn't the best way. So it all depends on circumstances, on context. There's no easy answer. And it also depends on what the law is in that country in relation to sales agents and distributors themselves. Hello, welcome back. This is Law, Goods and International Trade, how products travel across the world. In this lecture, we're going to be talking about foreign direct investment. Now we're really getting into the meat of the topic. This is when a company finally becomes multinational, when it becomes one of those big conglomerates that people all across the world know about, and it's on every billboard in the country. So the question that we're going to ask now with Alex, right? He's done so well to expand into Thailand with his green tea market, right? He's managed to have loads and loads of people. And if Alex retired right now, if he sold the company, I'm sure he'd go away a happy man. But as is often the case, people don't. Shareholders and founders of companies, they don't just stop there. He wants to now expand his business internationally. He wants to go to the next level. What's the best way for him to do that? Well, it's this thing called foreign direct investment. This unbelievably interesting tool, which has been used in international company law for businesses to just really branch out and become huge names in-house in the industry. So with Alex, he's managed to successfully sell his green tea all over Thailand. Now there's a well-established market for it. People are drinking his green tea everywhere. And Alex finds that it's actually inefficient now to run his business from the USA. Remember, he was making that green tea and shipping it all the way to Thailand. Well, that's inefficient for him now. So if he were to move his operations to Thailand, he could decrease his transportation costs, he can make use of cheaper labor, and you could help the Thai economy, right? You could increase Thai employment. People would get jobs, maybe lift them out of poverty. Okay, so this is his dream. And now Alex, what he wants to do, he's now wants to directly invest in Thailand through his business. And he wants to create a company, his own company, or move his operations into Thailand. And he can do that either through a subsidiary or a branch, with his parent company being the one initially registered in the USA. And a company who's made use of foreign direct investment is pretty much a company where a majority of the shareholders have their place of residence in a different state to the home state. And that will make them a multinational company. So if Alex initially made his or registered his company in the USA, and most of the shareholders, 100% of them being Alex, if most of them were US citizens, that would make that a domestic company, so a company in that home state. As soon as he's now invested in Thailand and he's moved his operations in Thailand and he's created a new company in Thailand, he's now a foreign shareholder in a foreign country. And so he would then be, the company would then be classed as a multinational company, having made use of FDI. This is just an example of an FDI company. The domestic shareholders might have a 49% share, whereas the foreign shareholders will have a 51% share. This is in Thailand, for example, and that company would have made use of FDI. But when do companies, and not just Alex's, but others, right? When do they actually invest in another country? And when is it beneficial for them to do so? Well, there's three reasons, actually, or three main reasons I've come up with. One is when the foreign market is large and well established. We know with Alex that's the case. He's been using distributors. He's been selling green tea all over Thailand, in Phuket and Bangkok, and all kinds of cities. And number two is when transport and shipping costs can be reduced. Remember, Alex is shipping his green tea from the USA to Thailand. It's quite expensive. Why not just move all the operations to Thailand? Then you'd have only these kind of trucks, in-road shipping instead of the big cargo ship. Make things quicker and cheaper. And number three is when local resources might be cheaper. Paying someone in the USA minimum wage, which is what, $8 to $10, is much more expensive than paying minimum wage in Thailand because the cost of living is so low, right? So you could easily get more work done, yet with half the price with Thai labor, for example. Or perhaps some other resources are cheaper. So if he's making green tea, perhaps the green tea leaves are cheaper in Thailand, maybe source cheap tea leaves in Thailand. Or perhaps water is cheaper, I don't know. So again, you need to make, a company will weigh all of these things into account before it decides to invest in another country. And in terms of applicable law, like we said last time, with sales agents and distributors, it's similar to this. There's no international treaty or convention. And so foreign direct investment, it's enforced by domestic law and specific areas of a domestic law if it exists. Now, a country might have so many foreign investors that it has its own area of called foreign investment law or investment law. And there will be lawyers specialized in this area who can help you. But some countries might not be as developed as that. And so they'll have other areas of law, such as company law, labor law, or bankruptcy law, which might be more relevant. It would all be about finding a lawyer in Thailand or a law firm in Thailand who are intelligent, who have dealt with foreign companies, who can help you invest smoothly in that country. How exactly does he do it? Well, he'll set up a company in Thailand, right? Or he'll take over a company. But there's two ways that you can do it, okay? In terms of types of companies you can set up, this is a very simplistic view, but normally these are the two main ones. So if you have a parent company in the USA in your home state, the original company, that would be called a parent company. And then these two, first of all, the branch and a subsidiary, would just be, you could say, a level below the parent company. So their relationship with the parent company is what will give them the name branch or subsidiary. So if you always remember that there's a parent company and you've got a branch and you've got a subsidiary. So comparing branches and subsidiaries, right? What is the difference between the two? And which one should Alex choose? Well, again, it will depend, just like sales agents and distributors, it will depend on market conditions, the country, whether it's favorable to foreign investment, what Alex's business plans are for the future. But here are some differences between both. So with a branch, it's not regarded as a separate legal entity. It's taxed as a non-resident entity, as if it's a foreign company. It reports to a head office, which would be the parent company in the USA, but often its setup can be it's much easier and much cheaper. A subsidiary, it's regarded as a separate legal entity. It's taxed as a resident company, and it can then make use of local tax benefits. It has an internal admin structure, so it won't necessarily report to the parent company. It will have its own reporting structure, but the setup can be complex and expensive. Now, the biggest difference, even though I've just mentioned it, between the branch and the subsidiary is probably overall this thing called the corporate veil. And the corporate veil, as a definition, if you think of a person and a company, they both have separate legal personality. So if for me as a person, I have the legal right to do things such as enter into contracts and etc., right? So I have separate legal personality. A company, in the same way, also has separate legal personality. If I can enter into a contract, Coca-Cola can also enter into a contract, or Nike can also enter into a contract, or Adidas or Range Rover, they can also all enter into a contract as just like a separate legal person would. The actions of that company, if it was to get into a dispute, it wouldn't be the shareholders of that company, the people running it, it wouldn't be them that were liable, it's the company itself. And this is this thing called a corporate veil, where the shareholders of a company are protected because they're in a company, right? So they'll be the ones making decisions, but they'll be protected. But sometimes that corporate veil, it can be what we call pierced or broken if the actions of the company's owners were illegal. And so a good way to relate this back to branches and subsidiaries is if we take a mother, it's supposed to be a mother, and if we take her family, or if we just specifically look at her child. If the mother was to punch someone with her left arm, right? If she was to punch someone with her left arm, rightly the law would prosecute the mother as a whole instead of just prosecuting her left arm, right? Even though technically, okay, I mean, you can say it was the brain that did it, but the actions were done by the arm. They wouldn't just prosecute the arm separately and then the mother separately. They would prosecute the mother as a whole. And so you can relate that to a branch. Think of a branch as being the arm of the parent company. So the branch, whatever the branch does, it reflects onto the parent company. So if the branch punches someone, it's the parent company that gets prosecuted, okay? Branch gets into a dispute, it's the parent company that has to bail it out. Now, on the opposite side of that, we have the subsidiary company. So in this case, imagine the mother has a child and it's the child now that punches someone. Now, rightly, the law would not point the finger at the mother, they would point the finger at the child because the child ought to have known better than to punch someone. So it wouldn't be the mother gets prosecuted for the actions of her child. It would be the child that gets prosecuted for punching someone. And so a subsidiary works in the same way. Even though they have this parent company, a mother, they are the ones that are legally liable. And this idea of the corporate veil is very, very key to understanding foreign direct investment and why a lot of companies prefer the subsidiary avenue. But with FDI, a lot of the time this also requires protection. And this issue became quite prominent after a very specific incident called the Suez Crisis. Let's say Alex invests in Thailand And then the Thai government decide that actually they don't like foreign companies anymore, and they're going to sell everyone's shares and take control of that company because they can do what they want, it's their territory. There needs to be some mechanism of protection, and that's exactly what happened during the Suez crisis. So in 1869, the Suez Canal opened. When we spoke about that in the shipping lecture. The Suez Canal opens. It's run by this company called the Suez Canal Company. And by 1875, the biggest shareholders in that company were British and French. And they were making extremely healthy profits. Because if you think about it, billions of dollars worth of trade is going through the Suez Canal every day. And so these shareholders are taxing, obviously, these ships, and they are making a ridiculous amount of money. So everything was all good until Egypt, which is where the Suez Canal is located, gains independence from Britain. And so Britain as the country no longer has control of the Suez Canal. It's actually technically Egypt because they're independent. And in 1952, the Egyptian monarchy, who had run Egypt since 1922, and they were quite favored by Britain and France because they were keeping the shareholders happy in the Suez Canal Company. The profits were still coming in quite healthy. They're toppled during the Egyptian Revolution. And the revolution is led by a guy called Gamal Abdel Nasser, an Egyptian pan-Arabist revolutionary, and he made the drastic step of nationalizing the Suez Canal, which is that he took the Suez Canal Company, he sold all of their shares to the shareholders so that they couldn't make constant profits anymore. So he just gave them a lump sum, sold their shares, and then that canal was now in the legal possession of the Egyptian government at the time. And so instead of the British and the French profiting from the Suez Canal, it's the Egyptian government now. And then the idea is that they will then help the Egyptian people who have been persecuted through colonialism. And so this caused the Suez Crisis. It caused Britain, France, and Israel to invade Egypt until it was called off by the USA. But you can clearly see how investment capital and money can lead to full-scale war. And so after this, a lot of companies in the West especially got really, really scared because they didn't realize that it was possible for them to have invested in developing countries such as Egypt, just for the governments in those countries to switch and then to nationalize everything, and then the company would lose all their money. They never realized this was a possibility. And the problem is that when companies are uncertain about their future in a developing country, it's much, much safer for them just to not invest in that country at all. And as we said before, the whole idea of a globalized economy is that companies from every country are able to invest and trade with every other country because that reduces war and conflict and poverty, etc. And so you want to make the law really, really certain. You don't really want another situation like Suez, because what will happen is companies will get put off from investing in not just developing countries, but any country where the government is not as favorable. That means there's not enough money flowing in the international system, which means there's no growth. Without growth, people stay where they are and incomes don't really change. And so it's a big problem. And so one of the ways the international community tried to regulate this was through BITs, bilateral investment treaties. These are little treaties that each country makes with each other to say that they're going to protect the company's investment, and the companies are able to invest a lot of money and provide resources into that country. So there's over 3,000 BITs concluded around the world, and the reason is because there's no international convention. Individual countries conclude it with each other. So if you're Germany, you've concluded separate BITs with France and Pakistan and India and China. And they've concluded, and China and India have been concluded with different countries like France and Portugal and Spain and the UK. And so everyone has different BITs going on. And so it's like this contract almost that these countries have entered into. And the trade-off in this contract is that developed countries protect their companies' assets, and the developing countries benefit from foreign investment. And so that's the trade-off. And that's how foreign direct investment is protected. And that's how the wheel of international trade and international investment keeps spinning. And you can create jobs and prosperity and growth in an idealized world. Hello, welcome back. We're nearly at the end of this course, Law, Goods and International Trade. And in the last lecture, we're going to be talking about the World Trade Organization, the WTO, and protectionism, and what actually is protectionism and how it can impact world trade. So the final question we're going to ask, and hopefully we've covered all the other ones, is how will Alex deal with foreign restrictions on his product? So what is Alex going to do if Thailand turn around and say, well, actually, Yeah, I know you've been selling here for ages, but we're going to start restricting your green tea imports. There are some options that Alex has to deal with this. But first of all, let's look at the scenario and where we are in Alex's journey in becoming a rags to riches story. So Alex's multinational company, remember, it's invested in Thailand now, it's moved its operation. So Alex's multinational company is thriving in Thailand. But the locals in Thailand, they've now discovered the secret to Alex's green tea, the magic potion that makes it so addictive that's swept around Thailand. And they're now creating their own Thai style green tea. Basically, Alex's recipe, except with a Thai twist. And the problem for Alex here is that Thailand's government favors domestic companies over foreign ones. And what it does then is it begins imposing restrictions on foreign herbal teas from coming into Thailand. And one of those would be Alex's company, because they know that it's actually a US brand originally. So they want to prop up the Thai boys, right? They want to they want to prop up the Thai population and have their own Thai rags to riches story, because who cares if an American does it? They're all rich. So in order to counter this, Alex needs to make use of rules stipulated by the World Trade Organization. They're going to come to his aid. And the WTO rules are going to challenge the Thai government's policies and ensure that Alex is able to compete fairly with domestic companies. So protectionism is one of the main themes of this topic specifically, but not many people know what it is. Protectionism is essentially government measures used to restrict international trade in order to help domestic industries. It's Thailand wanting to restrict foreign things from coming in order to help Thai people have their businesses and do well in their businesses. And so a really good example of seeing the impact of protectionist measures is if we go all the way to Germany. So imagine we're in Germany and imagine we're in the banana market. And we have, first of all, German locally sourced, locally produced bananas. And we have Spanish bananas, right? Foreign bananas that come in from Spain. And both are being sold in supermarkets. Now, before any protectionist measures that the German government will have put in place, German bananas, the local ones, they sell for €5. The Spanish ones, €3. So it's clear to see which bananas the consumer is going to buy. They're obviously going to go for the cheaper option, which, assuming that they both taste like banana, right? They're going to go for the cheaper option. And so they'll go for the Spanish bananas. So what the German government does is, well, because it favors Germany, it's going to impose protectionist measures on foreign bananas, and it's going to make them more expensive. And the idea is then that the German bananas are going to sell better. So after these protectionist measures, the German bananas become cheap because Spanish ones become expensive. Because as soon as the Spanish ones become expensive, less people start buying it. German bananas start to dominate the market, then they can cut their prices to €3. And then once it's €3, people start buying the German ones, right? But remember, it's not fair. It's not fair competition, because the only reason those German bananas have begun selling well is because they were helped out by their government, right? It's not fair. It's not fair competition. And the German government could do this for not just Spanish bananas, but French and Dutch bananas as well. And suddenly, what you've done is you've eradicated all the competition from those German bananas, so that you're only propping up the German ones, and all the foreign ones will pretty much go out of business. And so these protectionist measures, they can help or harm companies depending on whether domestic or foreign. So the specific types of trade restrictions that governments will impose, okay, is twofold. You first of all have these things called tariff barriers. And tariff barriers are, for example, taxes and duties imposed on foreign products. And the main thing is, it makes the products more expensive. So like the example we saw before in bananas, that's the kind of thing that the German government would impose, a tariff barrier. They'd make foreign bananas pay more tax and more customs duties that the local ones wouldn't be subject to, and so they'd become more expensive. Another type of barrier is non-tariff barriers. And these can take the place of quotas or bans, or really, really hard to fulfill requirements, right, on products. Maybe they have to be a specific shape or a specific size or something like that. Just makes it very hard for the company to enter the domestic market. I mean, if you have to go through so many regulations, right, and if you have to make sure it's this size and that size, and it's just, you'll have to then pay people to do that. And that's more cost and more expenses and more time. And so some companies will just be like, forget it, we're not even going to bother going to this domestic market because we can't make enough profit with the amount of time we spend tweaking these products and the amount of stress it causes them. These are the kind of barriers that some companies will put up as protectionist measures. You might even be saying right now at home, well, surely it's admirable that a country is looking out for its own, right? Surely it's admirable that Germany, funded by German taxpayers, is trying to prop up German companies, right? Surely that's admirable. Well, on the face of it, yes. But the problem is, as we'll see, is when you have these kind of nationalist economic policies where you care about your own all the time, it actually causes more problems in the long run. And we've seen that throughout history. But let's look at the advantages of protectionism, at least from the point of view maybe of the German government or the German population. Well, it allows domestic companies to grow until they can compete with bigger companies, right? So just some local companies, if a foreign competitor comes in, has been around for a long time, the domestic ones have no chance of rivaling them. So these protectionist measures can help the domestic companies make a level playing field, and then they can release those protectionist measures, and then it becomes a level playing field. So it can be used tactically. It lowers the cost of importing products if they're created at home. So a country doesn't need to start importing bananas if they can just make them at home and they're better not at home. And in general, this is really the main reason why countries have protectionist measures. It increases employment in the domestic country. So if the German local companies are now doing brilliantly compared to the foreign ones, those German local companies are going to start employing more Germans. And more employed Germans means more stability, means more taxes to being paid to the government. And so the domestic company wins out. Now, the problem is that long term, this is actually not a great strategy because consumers will have or access to fewer goods, right? Because it's only the German bananas now in the supermarket, no more Spanish or Dutch or French ones. And so there's less choice. And without foreign competition, an industry will stop innovating and it'll stagnate. You take those German companies, or maybe there's just one, and that German banana company now knows that the foreign competitors can never compete in its banana production. And what happens then is the German local banana companies become super, super relaxed. They don't make nicer bananas. They don't make them taste better. They don't make them bigger. They don't make a better color. They don't make them cheaper. They're getting a healthy profit year in, year out because of how the game is played. So they stop innovating, but who loses out in the end? It's German consumers. Because when companies become lax in innovating, consumers get a worse product. They get bananas that are old and out of date and colored like purple or some shit, right? So they look awful. And the consumers don't know what to do, right? They just thought they were helping out domestic companies. So you need foreign competition. And that lack of competition means higher prices, because if there's no competition, then the German company thinks, well, okay, there's no competition if we're selling them at €5. Well, there's not going to be any competition if we sell it at €10. Let's just do it at €10. So then they start to market their German bananas at €10. And so the German company starts to increase their profits, and consumers get a worse and more expensive banana industry. And so over time, yeah, it might have increased employment, but it's not going to be very, very beneficial for the population of Germany. Or at least that's the idea. And overall, with protectionist measures, the biggest criticism of it is that when goods don't cross borders, soldiers will. And this is the idea that if you have countries trading with each other, they're less likely to go to war with each other. And as soon as they stop trading with each other, you'll begin to find excuses to go to war, right? It's much, or at least the risks of going to war are much, much higher. And so this idea is really the fundamental principle or the fundamental basis for the World Trade Organization. Headquartered in Geneva in Switzerland, it was created in 1995 with 164 member states. And the whole idea of the WTO is that it has to regulate and facilitate international trade for all the reasons that we mentioned in the first lecture, to reduce poverty, to reduce war, human cooperation, etc. And one of the ways that the WTO does this is that it settles disputes between states on international trade issues. It has a really efficient and easy way of settling disputes through its own WTO panels, which see lots and lots of cases every year. In doing so, the main principles of the WTO are these things called anti-discrimination principles. And so these two principles that I'm going to speak about really do underpin what the WTO is trying to achieve or trying to combat, really. in international trade. The first of the most important WTO principles is the most favored nation principle. Now, this is where a country can't favor the goods and products of one country over another, and it cannot have different rules for different countries. So if I'm the Chancellor of Germany, I cannot give favorable rules to the Spanish bananas and not give favorable rules to the French bananas. That's not allowed. You can't favor one nation over the other. The second of the two most important WTO discrimination principles is the national treatment principle, that once foreign goods have actually entered the market, a country cannot favor the domestic ones over the foreign ones, and the rules have to be equal for both. And so this is very similar to our example in the banana market. Once those Spanish or French or Dutch bananas are in the German market, they have to be treated equally. They have to have the same customs and tariffs and taxes, and they have to be displayed similarly by law. But sometimes trade barriers actually are justified. So sometimes these protectionist measures, although I guess it wouldn't be then called protectionism, but some of these measures are actually justified. They're justified, for example, for the protection of public morals, right? So these are some justifications of the WTO, protection of public morals. They're justified sometimes for the protection of humans, animals, plants, or health. So for example, environmental reasons. They can be justified for the protection of historical or cultural artifacts. So if a product is about to disrupt that, and for the protection of national security interests, right, which is very, very important. And it's been used quite a lot by states recently. Even though we live in this really, really globalized economy where it seems that any nationality is able to equally trade and on equal terms with any other nationality, and that everyone's harmonized and they're all living in peace and happiness, a lot of the times people are always trying to push back against that. And things aren't as straightforward as they seem. And there's always going to be winners and losers in an international economic system. And so when you have too many of those losers, they will often rise up and start to impose measures such as these. And whether that's good for society or maybe even our planet is a question that's in the open, it's debated constantly. But this is the situation that we live in, it's the system that we live in. And understanding it, I think, is what is fundamental. So thank you so much for listening to this online course. It's my third in my series, my introductory law series. I've put a picture of an iceberg, right? And it's just to signify that this course is literally just the tip of the iceberg for international trade. Every single topic, every single keyword that I've listed in this 6-part lecture, you could write an entire dissertation on it, 10,000 words, okay? And people have. And so I've given you the bare bones of international trade law. If there is something in this course that you are really interested in, and you want to go ahead with, get some more information, then by all means do your own research, right? But I genuinely hope that this has given you some sort of introduction, that you're slightly better informed and slightly better educated. And as ever, we're learning together, right? That's the main thing. And if you are interested, if you have any questions, if you're interested in private legal tutoring, my email is there, harrisonmatin@gmail.com. Feel free to email me and rate and review this course. Bye-bye.